So the baby. Over.
Abusia yanche ana yemo akwaba emfa emla Accra High Court ni nyina eye chairman Wontuni sinsia NDC amanyoko no itimi ba power no chairman Wontuni edi court akwani abasa ene ka ho a chairman Wontuni ema court kura no waba over 13 times ena watimi aba na ene ba obepiem ewa ha ni nyina kire se ade a na count a sebi onye sika kakra o timi yi sika esendi sika kakra no mpenifo timi freeze no ene oba nanka ye bie account no ediama no na wanya konya etimi anya bibi kakra Christmas yi wanya bibi kakra ede ayespe dede but the beto odwa ene se mpenifo etimi kire se omonko na da wo chena omo entimi emna lawyer edema dia chema Wontuni apia kubi enya konya etimi edi nchirechiremu ebaye hawa enom bepiem ewo court no esiti ekoye.
Counsel, what happened in court today in relation to the Samara Boy case?
Samara Boy case, it was supposed to be case management this morning. When we came, we realized that some of the documents were not readable, documents they filed. And so we told the court that we cannot read these documents. They are not readable. And the court also looked through the file and also realized that it is true that those documents couldn't be read by anybody, notwithstanding even application of a magnifying glass.
Counsel, when you say they were not readable, what do you mean by that?
They were too faint to understand what is there. You can't read it. So we told the court that if the court would find that the court's copy could be read, then we could share. But the court also realized that they couldn't also read their own copy. And therefore, a need for them to bring good copies, readable ones, for us all to apply ourselves to those copies. So matter was adjourned to tomorrow for the prosecutor to bring us readable copies of those documents we complain about. So we'll come back tomorrow to take the CMC if they are able to serve us with the readable copies. On the other hand, if they decide not to serve us with readable copies, then those documents ought to be expunged from the records. Then we can proceed thereon. So for today, we are waiting for readable copies of the documents they have filed. We hope that by the close of the day, they will be able to serve us with readable copies for us to come back and do the case management.
What are these documents and how critical are they to this case?
They are documents before the court. We haven't even taken them. We haven't admitted them. We haven't applied them. So we are foreclosed in disclosing what is in there. But I can only say that there are documents that are not readable for which we raise objections. And the court ruled that they should bring readable copies.
Do you think that this was an intentional step taken by the prosecution to frustrate the case in a way?
No. I cannot undermine the work of the prosecutor. And I don't understand why it happened the way it did. And I also know that if there are readable copies there, they can furnish all of us, including the court, of readable copies for us to proceed. So as for today, what I can say is that these copies were not readable. And without more, we will wait for them.
Okay. I think, and after this case, you went to Commercial Court 5. What happened?
We have moved our motion. It had been responded to by Yoko, and the matter has been adjourned to Thursday for a ruling, if it's ready. If it's not, we'll take another day for them to come and do the ruling.
But what was the argument?
We are saying that they did not comply with their own governing law of the requirement of service of court processes on the person affected by the freezing order of Yoko. And the argument was that they had served copies of documents on me as counsel, and that they considered that service. My argument was that they have served me a lot of copies in different situations, but the law requires that a person affected by the prison order ought to be served, and timeously too. There is also a time limit within which service ought to be done, 7 days. And we are saying that they haven't served us even as we have now. And we relied on Order 7, Rule 1-2 of the requirement of service on a person affected, not on any other person. So this was the argument. So we wait for the court to rule. That we are saying that even as at now, we have not been so served. And we are saying that we are not statute barred. Because that was one argument of the Yoko, that we are out of time in filing the application. We are saying that time begins to run when notice is given to us. And that notice was so given to us when we've signed a check for the bank to pay. Otherwise, Yoko itself had not served us anything. And therefore, time will run from the day that we got notice of the freeze, not the day that they probably Nicodemously gave the order of freezing the accounts. So time will start from the day we got notice. That is our argument. So let's wait for the court to rule whether time starts, even if you do something in darkness. But I want to believe that, yes, we have stated the position of the law and cited case law to support our argument, and also stated position in the High Court Civil Procedure Rules, which talks about also service. So let's wait for the court to reconcile the two arguments and come out with a ruling.
Counsel, your client has been coming to court almost every week or two. How is he feeling looking at all of these legal tussles?
Well, the laws of Ghana requires that you appear before court if you are summoned. And if you look at the front page of every writ, it is so stated that if you don't come, the matter can continue without your presence. So it is a requirement of the law that when you are summoned to appear before a court, you ought to show presence. So my client has been religiously responding to all such invitations. And you bear me out that my client is almost the first person to come to court on each court date. And that we will not also attempt to delay the proceedings. We are always ready. So when the court is ready, we are always ready.
All right. Thank you very much.
Okay, P version, very simple. First time
na after say lawyer appear kubi enya akonya etimi ekasa wiye no ne lawyer ba kono so ede enchechirimu in akan kasa ede emaye yenya akonya na yenkotie san komo no emfa emra
boy concession case a war criminal court 4 ene ba court na case management na wo se ye ne ye sha ase na yegusu na ne hu se nkrata no a prosecution edema ye no bi ewo ho a wokenkan a enye yie ukofa lens sen kra wo de hwe enya ade a wo behu hwe enti ye twen judge na dwensi so se nkrata no bi ewo ho a wokenkan a enye yie enti judge no eye ne se sa na tie dia prosecution enkofa nkrata no sa nkrata kro na wokenkan ye papa wokenkan a ebeye yie emfambra court enti ya agenda sa case no e de court na a yebeba na yabetoa eye case management no so mutumi e de enkrata a eye papa okenkan a eye yie no e de court e de a ochina yebetoa case management no so court de no so se ne lawyer chim maamo no court no so hwe ne de no na okenkan a enya de a eye yie enti ochina yebeba court na yabetoa case management de no so court 5 commercial court 5 no so mbisa lawyer said in the scene no application na ye de aba court se yoko tabo ana se order na odi freeze the bank account no court no nhwe na order na yenyi free so lawyers no akotu ana se omo akansem omo be kan nyina omo abo omo nkro omo kotu all the relevant laws any cases judge no agene de koya wada ebay se nyame ya adom no timi twro ne ruling na yebeba abaji ruling yeba na enye ready a bema yen day foforo a yebeba court na ya abaji ruling no enti dey see court na eno no.
Thank you very much.
Thank you. Authentic and readable documents number, which is what it means processes.
I said the lawyer can say
uncomparable size.
Conformize and wow, chairman.